Bill for an Act to amend the Criminal Code, Act Cap C 38, Laws of the Federation of Nigeria, 2004. This bill attempts to delete portions of Section 218 and 221, amend the definition of rape as contained in Section 357, and increase punishment for the offense of kidnap in Section 364, and was first read on the floor of this Senate on Tuesday, 24th September 2019. The globally accepted aims of criminal law and the criminal justice system include deterrence, retribution, restoration, and rehabilitation of offenders. In addition, it delivers substantial justice and closure to the victim, the offender, and the state. Where a law fails to achieve any of these, it is inherently defective, hence the need for amendment. Section 218 of the Criminal Code provides that anyone who has unlawful carnal knowledge of a girl under the age of 13 or attempts same is guilty of a felony and liable to life imprisonment or 14 years imprisonment respectively. My grouse, however, is with the proviso that the prosecution of the offender must be commenced within 2 months after the offense is committed. What this does is impose a statute of limitation on prosecution of these offenses. This bar to prosecution negates the principles of natural law, equity, and good conscience. This is unattainable in a country where investigations often take longer than 2 months. Considering the shortage of police personnel relative to our population as prescribed by international standards, the 2 months limitation is unlikely to be met at all. With development and innovation in forensic technology and accessibility or otherwise of such infrastructure in Nigeria, rushed investigations with a view to commencing prosecution within a 2-month period leave possibility of a huge margin of error. In the event that police proceeds to prosecute outside the 2 months, all that it will take to dispel the entire charge is a challenge to the jurisdiction of the court on the basis that it was brought outside of the time allowed by law. Section 221 suffers a similar fate, wherein it provides that where a person has or attempts carnal knowledge of a girl, being of or above the age of 13 and under the age of 16, an idiot or imbecile, he shall be liable to imprisonment for a period of 2 years, provided that the prosecution is commenced within 2 months after the offense is committed. We are at a time where these sorts of crimes are on the increase daily, which we've just gone through in motion this morning. Daily, we are regaled with the tales of children as old as a few months being defiled. Should perpetrators of such crimes be allowed to go scot-free on the basis of the technicality that prosecution did not commence within 2 months? This bill also proposes an amendment to Section 221 to substitute for the word idiot or imbecile the words mentally challenged. While words like idiot, moron, and imbecile were professionally used to measure IQ, they have acquired pejorative connotations, become derogatory and obsolete, and should be no longer contained in our laws. The Criminal Code Act defines rape in Section 357 as an offense against women. However, times indicate that there are incidents of non-consensual sex perpetrated against the male gender. This definition is particularly grievous because it perpetuates the social cultural belief that men do not need to consent to sexual acts. In addition, we must ensure that our laws and jurisprudence evolve with the rest of the world. Section 364 provides a punishment of imprisonment for a term of 10 years where a crime of kidnap is established. For avoidance of doubt, as defined by the Act, kidnap is unlawful imprisonment of any person to prevent him from applying to a court for his release or from disclosing to any person where he is imprisoned. Simply put, stealing a living, breathing human. Curiously, the Act provides a term of 21 years for robbery, death for armed robbery. Where is the punishment for stealing property and replaceable things higher than what is obtainable when you steal a human being? The frequency of kidnap across the Federation and its resulting trauma, not to mention the number of lives lost to the crime, make it imperative to review our laws with a view to ensuring appropriate punishment for perpetrators and deterrence for would-be perpetrators. Thus, this bill provides a life sentence for person found guilty of kidnapping. It is my hope, distinguished colleagues, that by lending your voices in support of this amendment bill, we can check the rise of crime in our communities and ensure that those who contravene the law do not go unpunished. Mr. President, distinguished colleagues, in complying with Order 773, Section 777, Subsection 3 of the Senate Standing Order 2015 as amended, the prosecution of this bill has no financial implication. Therefore, I urge you all to kindly support this bill. Thank you very much for giving me the opportunity.
Senator Ahmed Adamu Alero.
Ahmed Adamu Alero, representing KB Central. Mr. President, let me first of all thank Senator Oluremi Tinubu for bringing this very important bill. Mr. President, many people got scot-free because of the provisions of the existing Act. The issue of getting the offender prosecuted within 2 weeks, Mr. President, is rather too short. And certainly it gives room for people to escape the course of justice. And I believe the only way we can do justice to the people is to allow a period of 2 to 3 months. Mr. President, in some societies, it is only after the pregnancy has become clear that the people will know that the girl is being defiled or she has been raped. And particularly in the northern part of Nigeria, where it is an abomination for people to come out and say their daughters have been raped. So I will suggest very strongly that we should extend the timeline to about 2 months. Mr. President, I was listening to a BBC commentary last week on the fate of a girl who was raped by one prominent businessman in a particular locality. And this prominent businessman is known to be doing that act for several times. And it was only through sheer luck that the arms of the law caught up with him. The police, the district head, and other prominent leaders got hold of him in the act, and they ensured that they took him to the police, and he is now facing justice. So certainly he will be prosecuted. Mr. President, many people have suffered this kind of humiliation simply because the law is defective. So this amendment is going to give cure to that aspect of the law that is defective. So I commend the mover of this motion, also of this bill, and sorry, the sponsor of this bill, and I urge all my colleagues to do the same. Thank you.
Senator Surajuddin Ajibola Bashiru.
Thank you, Surajuddin Ajibola Bashiru. I represent also Central Senatorial District. I also stand to support that the bill be allowed for second reading and to go for expeditious passage. The content of the bill is very germane, particularly in advancing the war against violence among gender. Generally, limitation of statute does not apply to criminal activities. So one wonders what was the rationale for providing 2-month period for instituting criminal proceeding in case of defilement of young ladies and the people who are mentally challenged. So I believe that the rationale, as it may be, if it were applicable when the criminal code was first drafted about 1897 and they adopted in Nigeria, I think in about 1904, is no longer applicable under the present circumstance and arrangement. In fact, as somebody who had cause to prosecute such kind of offense as an attorney general, I know how pretty difficult those technicalities had been used in aid of letting criminal or alleged suspects to go scot-free. So in terms of removal of the statute of limitation, I think it's highly commendable. And I will say that in addition, there's a need to strengthen our evidential situation, particularly as regards issue of prosecution for sexually related offenses. There have been experiences whereby possibly I've had an experience where a youth corporal doctor had the cause to carry out tests on the person that was the victim, but having been completed the service and prosecution was to go ahead, we had the challenge of how do you tender without the maker of that document. So there may be also a need to go further to ensure that whenever such medical record have been put in place and duly certified to having been made by relevant medical agency, it should be allowed to be used and tendered in evidence and dispensed with the requirement of the maker. Then on the question of extension of the offense of rape to be gender neutral, I think it's also part of the innovation that is not based on the traditional conception of what rape is. Of course, much is also to be commended in terms of additional penalty for the offense of kidnapping. And I also think that in making the offense of kidnapping to be far less in terms of punitive sanction than even stealing ordinary chattel, I think it's one of the loopholes in our law that this bill will certainly fill. So I'm happy to associate with the sponsor of the bill and to also urge colleagues to ensure that the bill is expeditiously passed. Thank you, Mr. President.
Mr. Capacity President of the Senate, my distinguished and respected colleague in the President, Senator Albert Basi Akwa Northeast. Mr. President, nobody is against this bill because of the consequences and the psychological damage as regards the issue of rape and other vices to the victims. I believe very strongly, Mr. President, that the amendment is apt and that the country will go to a greater extent to benefit from this amendment. Mr. President, I also believe that, based on the lead debate, that the issue of kidnapping should equally be given the absolute punishment level as that of armed robbery. And also when it comes to the issue of rape, Mr. President, women, sometimes we're also raped by women. So I think I also support that amendment that should also be as open as possible, such that the same applicable punishment that is applied to men who rape women can also be applied to women who will also rape some of us. So I thank you, Mr. President, and I thank the Mother of the Senate for bringing this and supporting totality. Thank you, Mr. President.
Senate Deputy Minority Leader.
Thank you. The intervention here is to bring to the notice of the Senate that the criminal code that is sought to be amended by this bill is only applicable to the southern states of the country, as it is. And the northern states of the country apply what is referred to as the penal code. Now, individual states in the southern states have equally gone further to domesticate the applicability of the criminal procedure code. Now, the intent of this bill is to make it of general application in Nigeria. And that is why we must commend Madam for taking this very, very good initiative. However, we will continue to raise these issues so that when the committee that is vested with the responsibility to look at this will bring an all-encompassing position that will not run foul of the provision of our Constitution, but that will still find some comfort in its general applicability to the entire country. Secondly, Mr. President, I'm happy that Dr. Sirajuddin has made it very clear. The issue of rape has been a very, very difficult provision in our statute. And it dates back to even when we received the English law. Salahuddin will tell you, under Section 45(1), Cap 89 of the Interpretation Act, we received this and then adopted it, do I say in toto or mutatis mutandis? But, while, I will give you the difficulty now, while the law itself says unlawful carnal knowledge, this provision is seeking to extend the issue of rape to the other opposite sex too. Now, if it's going to be an unlawful carnal knowledge, when you intend to apply it on the opposite side, what are you going to say? Now, our courts have done some efforts to raise what is called the ingredients of the offense, which I do not want to initiate here because of the nature of the offense. But I think that
we are trying to make a law. So in debates, there should be no whole bad. Say anything, everything that will guide us.
President, the ingredients of the offense of rape, Mr. President, at the committee level, we will try to see what we can do to dance around the matter. Thank you.
You are protected. I will put the question. Ayes have it. Clerk of the Senate. A bill for an act to amend the Criminal Code Act Cap C-38, Laws of the Federation of Nigeria 2004, to delete the statute of limitation on defilement, increase in punishment for the offenses of kidnapping, remove gender restrictions in the offense of rape, and for related matters 2019, second reading taken. And the bill is referred to the Senate Committee on Judiciary, Human Rights, and Legal Matters to report back within 4 weeks. Thank you very much, distinguished colleagues. Leader of the Senate.